Like to call the House Health Full Committee to order. Will the clerk please take the roll?
Representatives Boyd, Carringer, Clemens, Faison, Farmer, Gillespie, Hakeem, Hawk, Haynes, Hemmer, Hicks of Hawkins, Hicks of Washington, Jernigan, Kumar, Martin, Mitchell, Rudder, Sherrill, Travis, Vaughn, Whitson, Williams, Vice Chairman Leatherwood, Chairman Terry. Mr.
Okay.
Chairman, you have a quorum.
All right, thank you. And we do have a calendar. And before we get started, do any of the members have any personal orders? Okay, seeing none, we are going to go out of order, and we're going to take item number 3, House Bill 1051 by Chairman Vaughn. Chairman Vaughn, you are recognized. You have a motion and a second.
Thank you, Mr. Chairman. I appreciate the courtesy. I've got to present another bill in another committee as soon as this one's over. My amendment number is 4484.
Okay, let's see. Yes, we have Amendment 4484. Can I get a motion on that? You have a motion and a second. Okay, without objection, let's go ahead and get that on the bill. All those in favor say aye. Aye. Opposed? Ayes have it. We are back on the bill as amended. You are recognized.
Thank you, sir. Today I'm presenting you a bill that has been a product of negotiations between THA, the Psychiatric Association, TMA, and the Tennessee Department of Mental Health and Substance Abuse Services. The amended bill allows a physician to complete and sign either the first or the second certificate of need for an involuntary admission to an inpatient psychiatric hospital. Current state law allows qualified mental health professionals, including psychiatric APNs and physician's assistants, to serve as the first two required signatures on CONs for involuntary admission to psych hospitals, but requires the second signature to be that of a physician. This bill states that the first signature is completed by a doc, then a qualified PA or advanced practice nurse or PA, psychiatric qualified PA, can complete the second certificate of need for emergency admission and treatment. The thought here is that when folks are having a really, really tough time, we need to get them out of the emergency rooms and into a facility where they can receive treatment as quickly as possible. And with some of the limited resources of folks that are out there with regards to the docs and the psychiatrists, all these groups have come together and agreed that this would be the best procedure to allow for somebody to enter in. Let me point this out too. And this provision does not apply to the 4 regional mental health institutes with the state, and it allows an admitting psychiatric hospital to accept only one of those CONs if that CON comes from a board-certified licensed psychiatrist.
All right. Do we have any questions for the sponsor of the bill? Okay. Seeing none, we are voting on House Bill 1051 as amended. All those in favor say aye. Aye. Opposed? Ayes have it. Bill goes on to calendar and rules.
Thank you, Chairman and Committee.
All right. Thank you. That brings us back to the start of our calendar. House Bill 1388 by Chairman Reagan. You are recognized. You have a motion and a second, and there is an amendment, I believe.
The amendment number is 4593, sir.
Okay, 4593. Can I get a motion? You have a motion and a second. Okay, if there is not any objection, let's go ahead and vote on Amendment 4593. All those in favor say aye. Aye. Opposed? Ayes have it. We are back on the bill as amended. You are recognized.
Thank you, Mr. Chair and Committee. The Tennessee Board of Radiological Imaging and Radiation Therapy was created as a standalone board in 2016 with a directive to license and regulate the operators of radiological imaging and radiation therapy equipment in hospitals, outpatient diagnostic centers, recuperation centers, physicians' offices, or any other setting for human subjects. The original bill was sponsored by our current speaker, Cameron Sexton, and Senator Paul Bailey, both of whom have signed on to this bill to repeal it. Over the last 6 years, the board was unable to finalize permanent rules and establish any licensure process, making it clear the board is not necessary to safeguard the health and safety of the welfare of Tennesseans. Previously, this licensure practice was under the Board of Medical Examiners, and they have continued to exercise that function in the absence of any action from this board. With that explanation, Mr. Chair, and a reminder, let me emphasize once again, in the 6 years of their existence, they have not accomplished any of the mission for which they were created. I would appreciate a vote to move this bill forward, sir.
All right, thank you. And we do have some folks that have signed up to testify. Are there any questions for the sponsor before we go out of session? Okay. Chairman Clemens, you recognize.
Thank you, Mr. Chairman. I've received a lot of emails on both directions on this and received mixed messages from the profession itself on this legislation. Did the professionals themselves bring this legislation to you, or from where did this legislation come?
This
recognized.
legislation, Scott, I'm sorry.
You're recognized.
This legislation came about through government operations, sir. Boards come before us for review on a sunset basis. This board has not accomplished anything in the last 6 years. Recommendation was to terminate it.
You recognize.
Thank you, Mr. Chairman. So the impetus behind this legislation is the legislature, not the professionals themselves.
You're recognized.
You are correct, sir. The impetus to create the board is from the legislature as well.
Okay. All right. Without objection, let's go out of session. We have, I believe, signed up a Jennifer Thompson. There is a Paul Searfoss and a Terry Crutcher. Y'all can either all come up together. I think there's 3 chairs there, and give us your name and who you're with, and then each of you have 3 minutes.
On now? Yes. Okay.
Okay.
Good afternoon. I am Dr. Jennifer Thompson, a radiologic technologist board representative chosen by Governor Bill Lee. I oppose 1388 because limited scope technologists shall work only under their limited certifications. The bill eliminates 2008 and 2016 statute restrictions of limited scope operators of performing exams utilizing contrast, invasive radiologic procedures, CT, fluoro, C-arms, and MRI, which is beyond the scope and capability of licensed operators. Allowing limited scope technologists to perform advanced imaging beyond their 6 days of education is irresponsible and dangerous. The bill eliminates oversight of hospital radiologic technologists. There are over 8,000 technologists with 15,000 certifications working in Tennessee hospitals. X-ray, under the state's definition, includes radiography, CT, MRI, fluoro, nuclear medicine, mammography, and radiation therapy, all of which will have zero accountability to the state if this bill is passed. Hospital licensure adds additional safeguards and protection for patients for medical radiation exposure. Ionizing radiation is a type of radiation that can damage cells to the point of cell mutation or death. The lasting effects are not immediately seen, but increases a person's lifetime risk of developing cancer. Children who have a CT increase those risk of cancers to 1 in 300. The Division of Commerce and Insurance report places radiology in the top 10 of reported accidents and monetary losses. The bill removes the Radiologic Imaging and Radiation Therapy Board. In 2022, Governor Bill Lee approved the board's promulgated rules, and technologists began applying for application and began generating revenue. But in May, THA asked that they be withdrawn. The board worked with THA to add a grandfather clause so no one working within their scope in Tennessee would lose their jobs. In January 2023, these rules were approved by the board and were set for a rule hearing. If the rules are allowed to be moved to approval, the state of Tennessee would stay among the 41 other radiology licensure states, assuring safe and competent healthcare in radiology. I am a tenured professor in radiologic science, and I urge you to direct all certification and board-related questions in my direction. I took an oath of integrity, and that stands firm today.
All right, thank you for your testimony. And let's see, next, I guess we have Paul Searfoss.
Hi, can you guys hear me? All right.
Yes. All right.
Thank you, Mr. Chairman, and thank you, committee, for this opportunity to speak with you guys. My name is Paul Searfoss. I hold a degree in radiologic technology with a concentration in nuclear medicine, as well as an MBA in healthcare. I'm certified in nuclear medicine through the CNMT as well as AART, with my degrees in nuclear medicine as well as CT. Today, I wanted to talk to you guys because you may hear some comments about how the repeal of this board will still protect Tennessee residents, as it will still require staff to have state certification. That is only partially true, because this portion will repeal hospitals from that section, because the current standards that's set up through Tennessee X-ray licensure has X-ray operators working for offices of medical doctors, chiropractors, podiatrists, and osteopathic physicians are the only ones that this pertains to. That only pertains to about 20% of all imaging done in Tennessee, with 80% of it being made up by hospitals and hospital-affiliated facilities. So those imaging areas are the important key aspects that we focus on. This is because hospitals are reliant on Joint Commission and CMS. CMS does not set a minimum national standards for diagnostic imaging. As of September of 2022, CMS still has not established any health and safety standards for imaging. You'll also hear discussion about not having to have any documented reports for errors in healthcare in Tennessee or neighboring states. One of the concerns is you don't have to report medication errors, because the state would be overran with those reports. When you look at it, you only have to report neglect. So when we're leaving it to hospitals to sit there and minimize and prioritize themselves, we are putting our patients at risk. When we look at our neighboring states, I'm a proud Tennessean. I don't want to compare myself to Georgia or Alabama. I consider myself better than Georgia and Alabama, and that's why those residents are moving to Tennessee. So when you look at those things, we can't sit there and compare what they're doing. When you look at this board, the biggest thing that I'm proposing is you look at the amendments that all of the imaging accreditation bodies, which is ASRT, the Society of Nuclear Medicine and Molecular Imaging, ARRT that certifies technologists, as well as CNMT, all of them came together to come up with ways to protect our patients. Based off of these guidelines, when you look at it, the Code of Federal Regulation also encompasses advanced diagnostic imaging services as MRI, CT, nuclear medicine, and PET. When you think about that, these guidelines set it that only one certified technologist per shift is required to be in the hospital. How would any of us feel if only one certified surgeon was in the hospital? Thank you guys for your time, and I appreciate the opportunity to speak.
All right, thank you. That was perfect timing. So next up, we have Terry Crutcher.
Thank you so much for hearing our pleas today. I am a radiologic technology educator and have taught in both full scope and limited scope programs. Limited scope programs are designed to prepare persons to work in small medical offices or for chiropractors, podiatrists, and osteopathic physicians. They have the ability to perform a limited number of radiographic exams on patients. Under the existing law, those pursuing limited scope certification must complete a state-approved course of study, pass the limited scope ARRT certification examination, and obtain 60 hours of supervised clinical experience. The classroom course of study consists of 6 days of basic radiographic principles, 2 days in one procedures area, such as chest radiography. To add extremities to the scope of practice, the individual must complete 4 days of classroom study, 4 hours for spine, and 4 days for spine, and 2 days for skull and sinus imaging. The candidate then makes application to the state and takes a state certification exam. In contrast, full scope technologists complete at least a 2-year JRC accredited program with more than 1,500 hours of supervised clinical experience. There is a place for limited scope technologists in the radiography profession, mainly in small offices performing basic imaging procedures on patients. By removing limitations on their scope of practice, the legislature would be allowing limited scope technologists to perform more advanced procedures on patients, and one of those patients could be one of you. I am adamantly opposed to limited scope technologists performing CT scans, MRI scans, and fluoroscopic procedures on patients. They do not have the in-class training nor the clinical experience to do so safely. When the original law was enacted allowing limited scope X-ray practitioners in our state, the purpose was to define the scope of practice. This new bill removes any definition of the scope, essentially negating the original bill. We've gone backwards. As a registered full scope technologist, it's my opinion that this bill is a serious blow to our profession and sets us back decades in recognition of the importance of our role in healthcare. I implore you to take more time to review and understand the impact of this bill. In lieu of that, I appeal to you to add limitations back to the limited scope practitioner. Thank you.
All right, thank you. And while you guys are up there, and there's some other folks that are going to testify, I believe we have Chairman Hawk would like to ask you a question, and if any other members would like to be on the list to ask them a question, let us know up here. But Chairman Hawk, you're recognized.
Thank you, Mr. Chairman. Ladies and gentlemen, thank you very much for being here. We've heard earlier that this was a 2017 legislative initiative to create this board, the Board of Radiologic Imaging and Radiation Therapy. Why had you not accomplished those legislative goals by that May 2022 meeting?
You're recognized.
Jennifer Thompson. So those, the rules were approved in 2022, but the THA wrote a letter to the state asking us to remove the rules. And it's because they want limited scope technologists to perform CT and MRI. They will testify that there's 1,000 limited scope technologists that will lose their job. This is absolutely incorrect. CT and MRI is not within their scope of practice. So in November of 2023, we worked with THA, put them on our board so that we could write new rules. Those rules have been approved. We are ready for a rule hearing. Once those rules are passed, we'll be able to license in Tennessee.
Chairman Hawk.
Thank you, Mr. Chair. I'm going to read from the fiscal note. Pursuant to Tennessee Code 4-29-121, all health-related boards are required to be self-supporting over a 2-year period. The Radiologic Imaging and Radiation Therapy Board of Examiners had a deficit of $23,613 in fiscal year 2021, a deficit of $52,293 in fiscal year 21-22, and a cumulative reserve deficit since that 2017 timeframe of $369,465 on June 30 of 22. What are we spending money on?
We're spending money on the staff and the lawyers to promulgate the rules. I will tell you that most of the funding, so limited licensure, is still under the Board of Medical Examiners. All of that money goes to the medical board examiners. It doesn't go to us. In May of 2022, we started making money from those full scope applications, but the state had to pay all of that money back because the THA asked us to revoke the rules. We were extended to 2025 at the 2021 hearing. And so we were given time to be able to get those rules and to start becoming self-sufficient. With 8,000 technologists needing to pay their application fees, that will come very soon.
Chairman Hawk, you good? Okay. Any other members for the panel? Okay, seeing none, thank you for your testimony and appreciate you guys being before us. And while we are out of session, like to call up Zach Blair and Thomas Kidd. And again, for the record, who you are and who you're with, and each of you have 3 minutes.
Thank you, Mr. Chairman and committee. Zach Blair with Tennessee Hospital Association. I have with me Thomas Kidd, the CEO of Macon Community Hospital. If you have any questions about the impact for rural facilities, if the rules that we have been discussing for the last several months, and you want to know what the actual impact is to rural hospitals in Tennessee, Thomas can absolutely answer those questions for you. But I just want to be brief and give a basic description of what we're trying to do and what the bill before you is trying to accomplish. In 2016, Chairman Bailey and now Speaker Sexton passed this legislation to create the board. We were given inaugural rules back in May of 22. Those rules would negatively impact about 1,000 imaging professionals in Tennessee and would essentially and potentially be the end of 24/7 imaging services in rural hospitals in Tennessee. And I think that's why Thomas can give some really good feedback for you if you have questions related to that. The bill, and we tried to make it as simple as possible, the bill is simply trying to return the statute to its 2016 state before this bill is passed. The reason the board was created and I was able to watch testimony is to protect the health, safety, and welfare of Tennesseans. At that time, the question was asked, are there any safety-related issues related to these professionals? The answer at that time was no. I asked the Department of Health last week, have you had safety-related issues related to these professionals? The answer continues to be no. So we do not believe that that justification still is in place, and the questions still remain, is this necessary? Our professionals in hospitals have to go through robust certification and accreditation requirements to have professionals do this work in hospitals. It is correct. The hospital employees will not go through the same exact certification process. We are simply returning in statute the process that is in place right now for imaging professionals in Tennessee. And that's what the bill is trying to accomplish, and to make sure that our workforce can continue to perform these very important procedures in our facilities throughout Tennessee. Thank you, Chairman.
All right. And Mr. Thomas Kidd, you're recognized.
I can speak to what the proposed rules would do to our local facility.
For the record,
I'm
say your name and who you're with. And
Thomas Kidd from Macon Community Hospital. I'm the CEO there. We're a small rural hospital, 25-bed critical access hospital up in Macon County, Tennessee. We're open 24/7, 365. If these rules went into place, what it would do to our small hospital, we would have 7 employees would no longer be able to work in the radiology department. Either they'd have to go back to school, or they would just simply move to Kentucky where they do not have these rules and continue to perform the same things they're doing now. Our CT coverage, which right now is 24/7, 365, would drop to 5 days a week, Monday through Friday, 8 to 4:30. That means anybody that came to our facility in emergency for trauma, internal injuries, strokes, cardiac, we would not be able to take care of them. We'd have to transport them to a higher level facility. We are having trouble getting EMS transports now. That would, according to our statistics, that would add 5.1 transfers per day for our local EMS, because we would not be able to take care of those patients after 4:30 or on weekends. MRI services would be discontinued. Mammography services would either be discontinued or severely limited. Bone density studies would be discontinued. We have a lot of programs we have for local community that are targeted toward uninsured, underinsured, marginalized citizens, free screenings or severely reduced price screenings. We would have to terminate all those because we would not have the staff. Those are the facts about how it would affect your rural hospitals. There are several other hospitals in the state that we have talked to, and it would have similar impacts on them. So we beg you, please pass this bill so that we can take care of our patients. Thank you.
All right, thank you. And does the committee have any questions for the panel? We are out of session. Okay, see none. Thank you for your testimony, and without objection, we will go back into session.
Thank you, Chairman.
Thank you.
Chairman Reagan, you are recognized.
Thank you, Mr. Chairman. 6 years. 6 years this board has existed to do what it was chartered to do. Rule promulgation typically takes 6 months. Yet we have a situation where they're saying, we're going to be hurt, things are going to get bad, but they haven't changed a thing in 6 years. The Board of Medical Examiners had the authority and the responsibility for licensure and all of the other issues that were mentioned prior to 2016 when the first bill was passed. They have exercised it for the last 6 years. They will continue to exercise it if this bill goes through. I'll close with a thought, and that thought is either get it done or get out of the way. They haven't gotten it done in 6 years. I ask for your support on this bill. Thank you, Mr. Chair.
Representative Keem, you're recognized.
Thank you, Mr. Chairman. Chairman Reagan, I'm as confused as I can be. I'm trying to understand if it's how much training individuals have, or is it that this board has not, quote, done anything it's supposed to do?
You're recognized.
The answer to your second question first, the answer is no, they haven't. The training that they have, their licensure requirements, all of the requirements are being supervised and set forth by the Board of Medical Examiners, which was doing it before the 2016 bill, has been doing it since the 2016 bill, and under this legislation will continue to do it. The Board of Medical Examiners is the home of this. And they had the opportunity to change that based on all the criteria that you heard mentioned, all the training they said was required, et cetera. They didn't get it done. By way of analogy, if you hire a contractor to build a house and they tell you it's going to take 6 months to get it done, you say, all right, and 2 years later, nothing's happened, and 6 years later, nothing's happened. Are you going to continue to employ that contractor? I submit you probably wouldn't.
Okay. Thank you, sir.
Any further questions for the sponsor of the bill? Chairman Kumar, you are recognized.
Thank you, Mr. Chairman, and thank you, Mr. Reagan. We know that, of course, GovOps looks these things over, but I'm a little concerned that 6 years passed by and this problem was not discovered before.
You recognize?
The problem was discovered before, sir. They came before us and said they'd get it done. We gave them a continuation. It hasn't happened even since that continuation.
Chairman Kumar.
Thank you. I mean, I would be surprised if something was not getting done and for 6 years nobody would notice. Thank you. The only other thing is, and I'm sure you will kindly assure us that as far as this change is concerned, where the board is eliminated and the supervision and enforcement of rules and licensing is moved back to the Board of Medical Examiners, it would not create any safety problems as described by those who testified.
You recognize?
The Board of Medical Examiners continued to exercise the supervision and the requirements that they were doing prior to the passage of the 2016 bill. Nothing changed while they were waiting for this board to put forth new rules and requirements. So the straightforward answer to your question, nothing's going to change. The Board of Medical Examiners has did it before. They've continued to do it. They will continue to do it.
Thank you. Thank you, Mr. Chairman.
All right, thank you. All right, any further questions? Okay, question has been called without objection. We are voting on House Bill 1388 as amended. All those in favor say aye. Aye. Opposed? Ayes have it. Bill goes on to government operations.
Thank you, Mr. Chair and Committee.
And thank you. That brings us to item number 2, House Bill 283. Representative Baum, you are recognized. You have a motion, a second.
Thank you, Chairman Terry. Under current state law, hospitals are required to offer the flu shot and the pneumococcal shot to patients who are age 65 and older between the months of October the 1st and March the 1st. This is a bill that would change some of that. It would require hospitals to offer the flu shot to individuals who are 50 years of age and older during those time periods. And it would require hospitals to offer the pneumococcal shot to patients that are the same age as currently, 65 and older, but year-round.
All right. We have some folks that have asked to testify. So before we go out of session, do any of the committee members have any questions for the sponsor of the bill? Representative Travis, you recognize?
Thank you, Mr. Chairman. And Representative, this is just offer, not make anyone take a shot. This is just to offer the shot.
That's correct. The
from
hospital would just offer the shot. The shot could be declined. That's the current basis on which it's offered. It just moves the age level down for the flu shot and makes the pneumonia shot year-round.
All right. Chairman Vaughn, you recognize?
Thank you, Mr. Chairman. Representative, what is the thought process and logic behind compelling the hospitals or forcing the hospitals to have to offer this for this 15-year time period? What has changed? What are we seeing? I don't understand why why it couldn't be permissive. It's the compelling part of it that I'm having an issue with. But what's the thought process behind that?
The impetus for this was that the CDC changed its recommendations. And when the CDC changes its recommendations under federal legislation, hospitals are required to offer these shots in accordance with CDC recommendations. Now, the shots are paid for by insurance companies. Depending on who the insurance company is, it would be paid for by a private insurance carrier if that's what an individual has, or by TennCare if it's a TennCare recipient.
Chairman Vaughn.
So if there's already a federal mandate that they require this shot to be given, why are we getting in the middle of that business? It would seem that if, again, I have a problem with the compulsion of it. Where does the logic that a hospital, how many hospitals do we have that don't offer this if it's if it's now the standard of care or the CDC has now picked it up? Why is this legislation needed, I guess, would be the question.
Okay, and maybe I misspoke. The hospitals are would be required to offer this at the state level since the CDC now makes these recommendations. So the CDC is what's making the recommendation at the federal level. It would be revising state code that would require hospitals to begin offering these shots. There may be hospitals that would offer these shots in spite of the legislation, but this bill would require hospitals to begin offering these shots for these additional groups. And the rationale for this is that we're finding that it's not just people who are 65 years of age and older that have different comorbidities like diabetes or cardiovascular problems, or who suffer from obesity, something like that. People who are between the ages of 50 and 65 have some of these same problems. Even though they're just a little bit younger, they have some of these same risk factors. It's these risk factors that have resulted in the CDC changing their recommendations. And so by changing state code to correspond with these CDC recommendations, it would allow these patients the option to receive these shots. And again, they would be paid for by their insurance companies.
Chairman Vaughn.
Thank you, Mr. Chairman. I appreciate your indulgence. Again, and I'm a simple guy, but this still seems to be government reaching into a business and telling it what to do with regards to how it runs its business. And so that is what I'm struggling with mightily here. This is no different than us reaching into many other types of businesses and compelling someone to do something. If it was something they wanted to be doing, then there's no need of the legislation. So I'm going to sit back and listen intently to the testimony, sir.
All right, thank you. Chair Carringer, you are recognized.
Thank you, Chairman. And yes, I also had a question for the sponsor. So to my knowledge, I believe most hospitals already are doing this and will ask. So I don't know that it's necessary and also requiring the hospitals to do this. So I'm wondering about the cost of monitoring it and then enforcing it and the compliance that a hospital would have to undergo. I mean, to my knowledge, I think pretty much all of them already offer this because, I mean, a lot of your skilled nursing homes and all will require before a patient can go to maybe have the flu shot or something. So I'm sharing the same concerns with my fellow champion down there on the other end. I'm not seeing the need for it and the cost and the compliance with it. So that's my thoughts on it.
Chairman Baum.
If a hospital is already offering these shots to these additional age groups, then the legislation would not affect them. If a hospital is not already offering these shots to these additional age groups, then the legislation would affect them. And the fiscal note is zero. It's insignificant.
Okay. Chairman Leatherwood, you're recognized.
I think my question has already been answered questions, but just to be clear, the hospitals can do this now, correct?
A hospital could do this now. State law requires hospitals to do it for individuals aged 65 years of age and older. This bill would require hospitals to offer these shots to individuals between the ages of 65 and 50 and 65, like the hospitals are being required for those 65 and older. It's possible that a hospital may already be doing this, but it's also possible that there are hospitals out there that are not.
Okay.
And thank you. I do have one follow-up question for you before we go out of session. And we've had issues throughout medicine with supply chain and manufacturing of drugs or anything like that. How would you perceive a hospital right now? They're doing this on their own, but say there's a supply chain shortage of the vaccine, and now they're compelled to offer it, but they don't have it. I mean, how do you reconcile with that?
This bill includes provisions that state that if there is a shortage in supply, then a hospital is not required to comply with the law. This bill would be subject to availability of the vaccines.
Right. Great, thank you. All right, so without objection, we're going to go out of session. There is Denise Sibley and Bernadise Pager, I believe, that have asked to testify. Okay. Okay, Denise is not here, so are you Bernadette? Okay. At the chair there, and turn on the mic, tell us who you are and who you're with, and you will have 3 minutes.
Okay, is that on? There we go. So hi, thank you for hearing me today. I'm Bernadette Pager, and I'm just representing myself. So I'm very glad for this bill because it brings an opportunity for you all to review this existing law that it amends. It's Tennessee Code Section 6811266, and it's from 2007. I keep hearing in committees that it's not the place of the state to tell businesses what to do. And in most circumstances, I completely agree. When it comes to medical interventions, I absolutely agree. I believe if you review this flu shot offer law, you'll find it's both unnecessary and potentially dangerous for patients. First, hospitals, can set policy without law, absolutely. And they are financially incentivized to do so. So the CDC publishes a general best practices guidelines for immunization. On page 52, it states, quote, hospitalization should be used as an opportunity to provide recommended vaccinations. Healthcare facilities are held to standards of offering influenza vaccine for hospitalized patients, so providers are incentivized to vaccinate these patients at some point during hospitalization. So we've got hospitals being financially incentivized to offer the flu shots, and we know that they do. They offer them sometimes multiple times during your stay as a patient if you decline it, and it's offered in what seems like highly inappropriate situations. Like when my pop fell off scaffolding a few years ago, and my mom brought him to the ER bleeding with severe brain injury, and the first thing they asked him, has he had a flu shot? And she was not happy with that question. They bugged him throughout his entire stay, even though they kept declining it. Also, on page 52 of CDC's best practices, it says that the decision to administer or delay vaccination because of a current or recent acute illness depends on the severity of symptoms and etiology of the condition. So clearly, the offer of a vaccine must be individually determined. The CDC Best Guideline goes on to say vaccination should be deferred for persons with a moderate or severe acute illness. This precaution avoids causing diagnostic confusion between manifestations of the underlying illness and possible adverse effects of vaccination, or superimposing adverse effects of the vaccine on the underlying illness, unquote. So the CDC does have a list of contraindications for flu and pneumococcal vaccines. The problem is those are general, not patient specific. There are no safety studies on the administration of vaccines for the countless number of hospital medical conditions and stages of recovery that patients are in. Because there are no studies, CDC does not have a massive list of contraindications for hospital situations. But the absence of studies doesn't mean contraindications don't exist.
All right, thank you. You're at your 3 minutes.
Can I read my final closing?
Close real quick.
Okay. In closing, I encourage you all to take this opportunity to re-examine this existing law and think about repealing it. Hospitals can offer vaccines to patients without a state law, and they are incentivized to do so, but only doctors can make the call about whether or not the offer is prudent and in the best interest in the health of each individual patient.
All right, thank you. Do we have any questions while we are out of session? Okay, seeing none. Thank you for your time. Appreciate you coming before us. So without objection, we will go back into session. Chairman Baum, you are recognized.
I guess my response to that would be the bill does say that the offer of these vaccines would be made unless contraindicated.
All right, thank you. Do we have any further questions for the sponsor of the bill? Okay, seeing none, without objection, we are going to vote on House Bill 283. All those in favor say aye. Aye. Opposed? No. Bill fails.
Thank you.
All right, that brings us to item number 4, House Bill 155. Chairman Hicks, you are recognized. You have a motion and a second.
Thank you, Mr. Chairman. Members, House Bill 155 would provide an $800 training supplement for licensed emergency medical personnel who are employed full-time for an ambulance service upon completion of 40 hours of annual training.
Do we have any questions for the sponsor of the bill? Okay. Seeing none, we are voting on House Bill 155. All those in favor say aye. Aye. Opposed? Ayes have it. Bill goes on to Finance, Ways and Means. All right. That brings us to item number 5, House Bill 883. Chairlady Haynes, you are recognized. You have a motion and a second. And
Thank you, Mr. Chairman.
you have an amendment.
Yes, I do. Drafting code 5705.
You have a motion second on drafting code 5705. Would you like us to put that on or?
Yes,
Okay,
please.
without objection, voting on amendment 5705, all those in favor say aye. Opposed, ayes have it. Would you like to, well, you have another amendment, 5763. Would you like to put that on as well?
Yes.
Okay, need a motion? You have a motion and a second. Okay, without objection, we're voting on amendment 5763. All those in favor say aye. Aye. Opposed, ayes have it. If you'd like to be recorded as a no on that, please notify the clerk. Okay, you are back on the bill as amended.
Thank you, Mr. Chairman. Good afternoon, members. I'm here today to present House Bill 883, which has been called the Life of the Mother Post-Dobbs Cleanup Bill. This bill does have two amendments, and I would like to explain the first one, which rewrites the bill. It adds that the termination of an ectopic or molar pregnancy to the definition of abortion, changes considerations for criminal abortions in existing code as follows: removes language pertaining to an affirmative defense, changes references of good faith medical judgment to reasonable medical judgment, and permits abortions necessary to prevent the death or serious risk of substantial and irreversible impairment of a major bodily function of a pregnant woman. And it adds language that this bill supersedes several other sections pertaining to abortion, makes several other changes to existing law pertaining to the implementation of the bill. And House Amendment 5763, it requires the Department of Health to report quarterly the number of abortions performed in the state to the chairs of the health committees in the Senate and House, the speakers of the Senate and House, and the governor.
All right, thank you. And do we have questions for the sponsor of the bill? Okay, Chairman Williams, you're recognized.
Thank you, Chairman. Thank you, Chair Lady, for your hard work. Come see me today. I appreciate the diligence that you've done. This is a very important topic and subject matter. I think you've done a pretty good job. I have a few what I think are questions, but I don't know if you'll be able to answer them. It may be a legal question, so
Okay.
Feel free to use that legal card if you need. So one of the questions that I had is what's different that I read in this bill versus the original, in this amendment versus the original amendment, is to the language as it relates to terminate an ectopic or molar pregnancy, as well as remove a dead fetus. In your opinion, are these the three instances where this life-saving abortion could take place? Are these the only three?
Well, this clarifies that terminate an ectopic or molar pregnancy is not an abortion.
Okay. I guess the question is, in the original amendment, there was discussion regarding multiple things like medically futile or things like that. Is that language still in the bill?
This bill says to prevent the death of the pregnant woman or to prevent serious risk of substantial and irreversible impairment of a major bodily function. So the physician has to use his reasonable medical judgment, which is an objective standard.
Okay. And so that objective standard is what was replaced previously by which is what was deemed the affirmative defense. Is that correct?
Yes.
Okay. There is one other question, and I may show a little bit of my gray hair here. When abortions were performed in Tennessee previously, I vaguely remember where those that performed abortions would be required to have some credentialing at their hospital or at a surgery center. I don't know if now that the revisions because of Hobbs and this law, whether those attending privileges would still be necessary or would they not be necessary?
Are you talking about the facilities needing to be licensed?
The practitioner needing to have attending privileges at the facility in which this was performed.
Yes, they would.
Okay. Thank you.
All right. Chairman Leatherwood, you're recognized.
Thank you. And I also appreciate the work you've done on this bill. It's gone a very long distance here, and appreciate your diligence and patience with all the twists and turns on this road. I had a couple of questions here, and same caveat, you may end up needing to defer to legal. But looking at section 4 of this bill, where it says, section 3915-201 is amended by deleting the section. So it deletes the entire section of 3915-201, most of which, I'm perfectly fine with, but I did have a question with 3915-201B3. Just question whether or not we want to delete that as well. What that subsection is, every person who compels, coerces, or exercises duress in any form with regard to any other person in order to obtain or procure an abortion on any female commits a misdemeanor. A violation of this section is a Class A misdemeanor. So again, I like where you've gone with this bill. It's gone very far, but I do have some concerns with deleting that, and potentially maybe this was just unintended consequences. I know I've heard, maybe others have, a boyfriend or a family member who does do that: compel, coerce, exercise duress, and I would feel more comfortable leaving this penalty in there. And again, I'm not trying to stop your bill today, but if this is something that's of concern to other members, I think it'd be good to reflect on that. So any thoughts on that section? Then I do have another question as well.
Cheerleader Haynes.
Do we need to defer to legal to explain that further?
If you like, without objection, let's go out of session. And I will have legal answer that here just shortly. Without objection, we're going to go back into session. Without objection, we're going to take a 1-minute recess.
What do you think about that? Well, I think you have a point. I was going to look at the code, but it appears well.
All right, we are back in session. We're back from recess. So without objection, we will go out of session to talk to legal. You are recognized.
Anastasia Campbell, Office of Legal Services. Representative Leatherwood, I believe, asked the question about deleting a provision of coercing or using duress to force someone to have an abortion. Yes, he is correct. That provision has been deleted, but I'm going to refer to our House Judiciary Attorney who's going to reference a provision in the General Criminal Code that applies to when someone coerces someone to commit a criminal offense.
You recognize.
Michelle Fogarty, Legal Services. Under TCA 3911-402, a person is criminally responsible for an offense committed by the conduct of another if they are acting with the culpability required for the offense. The person causes or aids an innocent or irresponsible person to engage in conduct prohibited by the definition of the offense.
Okay, while we're out of session, do you have a question for legal? Chairman Leatherwood, you recognize.
What is that offense? What is the level? What's the consequence?
It's not specified here. I believe it would be the same as the offense. It would be the same level of felony offense as the abortion.
C felony. BC felony.
Class C.
So the person compelling, coercing, or exercising duress would end up committing the felony?
The underlying felony, yes.
Okay. And do you think that that would be directly related to this? Why did we have this in the code currently if it wasn't needed?
Those are policy decisions made by the body.
Yeah. But I appreciate the explanation, and actually it becomes more of an offense if a prosecutor used that section of the code. You know, this section makes it a Class A misdemeanor. But again, I'd feel more comfortable leaving this in to give a prosecutor someone more options. And of course, they could go with either section, it sounds like, from what you're saying.
Okay. Any further questions while we're out of session? Okay, without objection, we're going back into session. I believe you had other questions, Chairman Leatherwood?
With section 5, it deletes the subdivision 3915-219A6, which is the definition for medical emergency. And again, let me say, in the big scheme of things, where this bill was, where it is now, these are smaller things, but what can I say? They just came to me here, so I'm sharing them. It deletes the definition for medical emergency, yet later in 3915-219, the term medical emergency is used. So we're deleting the definition for medical emergency in 3915-219, but then later on in that same section of code, we're saying within a reasonable time following a medical emergency in situations where a medical emergency prevents the pregnant woman from completing the forms, whatever. So why are we deleting the definition of the term, and then we're using the term? Again, it seems to me like it would be better to leave the definition in there. I don't know where it does any harm leaving it in there. I don't see where it does any good really deleting it. And in fact, medical emergency is defined 2 other places in code with two slightly different definitions. So why not leave it in?
Would you like for me to defer to legal? and that's why it was
Whatever your
removed.
thought. You could just say, boy, these are great ideas, and I'll consider both of these as a friendly amendment when in the next step of the process.
My only answer is this is the same amendment that Tennessee Right to Life has approved of and signed off on.
To your point, 3915, 219A6 says medical emergency has the same meaning as defined in 39211, so it refers back somewhere else.
But we delete that. We delete, what you just read, this bill, this amendment deletes. It doesn't? Section 5, Tennessee Code Annotated 3915, 219.
Without objection.
A6, which is what you just read.
Without objection, let's go out of session, have legal. Without objection.
Michelle Fogarty, Legal Services. The amendment supersedes 3915-211, so it would not be proper to reference it because it's being superseded. As a matter of law, it would be improper to reference another section that's been superseded.
Yes. Yes, and that makes sense. And that's where, again, as you just said, 3915-211 has a definition of medical emergency, and it actually uses the language good faith. And in this process, we've been moving away from good faith. However, 3915-218 also defines medical emergency, and it actually uses the terminology we've been moving towards, the reasonable medical judgment. So again, it seems to me that leaving a definition of medical emergency in here, and frankly, I prefer the 3915-218 definition. It seems like that would be good to define it, since again, we're using the term in the bill, if that makes sense. Why not define the term that we're using later on?
Those are policy decisions for this body to decide. I will say that
Yes.
3915-211 and 3915-218 are both superseded by the language in this amendment, so it would be improper to reference either one of them.
Correct. But again, we could put the definition in this amendment.
That's a policy decision for the
Yes.
body.
All right, without objection, let's go back into session. All right, you are recognized.
Well, those were my two points that I would feel more comfortable. Again, in the big scheme of things, not trying to stop your bill or anything, but I would feel more comfortable with these two items, back in place. We're deleting them now. I'd feel more comfortable if they were not deleted. But as legal alluded to, I do think they're a policy decision, will of the committee and the body. Thank you.
Thank you.
Thank you. And to that point, I do believe that with this superseding, if you have conflicting code, which these parts are trying to remedy, it firms up the defense of this because you do not have conflict in the code. So with that, I will recognize Representative Hemmer, you're recognized.
Thank you, Mr. Chairman. Under this bill, who determines how much risk is or to the mother's life is enough so the patient and the doctor can offer health care and not face criminal prosecution?
Who determines? The physician would. He would use his reasonable medical judgment.
One thing that I was concerned from this in the last amendment is how it doesn't address the non-viable pregnancies or fetal abnormalities. Knowing I have personal friends have had these situations, and it's been I've seen up close how it's very physically, emotionally troubling, and as well as detriment to the life of the mother. So in situations like that, how will a physician use their reasonable medical judgment to ensure that, when the baby and the mother's life's in danger, that they are protected?
If the life of the mother is endangered by a fetal anomaly, a lethal fetal anomaly, I believe it would be covered under the reasonable medical judgment.
Thank you. Representative Mitchell, you recognize.
Yeah, thank you, Mr. Chairman. So under this amendment, are there some abortions are allowed under this amendment, correct?
Yes, to save the life of the mother or to prevent any substantial and irreversible impairment of a major bodily function.
You recognize.
And did you say Tennessee Right to Life agreed and approved of this amendment?
Yes.
All right. Next question is, let's say we have a 15-year-old child and she's in foster care in the state of Tennessee and she's raped in foster care in the state of Tennessee. Will your amendment allow for her to get an abortion?
If her life was in danger, yes.
But that's the
believe so.
only, so,
If her life was in jeopardy.
so not just because she was raped under the
No.
care of Tennessee.
No.
Okay. What if an 11-year-old child was raped by her uncle and became impregnated? Would she be allowed to get an abortion?
Not unless her life was in danger.
How about if a woman is pregnant and diagnosed with cancer that requires chemotherapy or radiation? Will she be able to terminate the pregnancy so that she can undergo the chemotherapy or radiation?
I believe if her life was in danger, yes.
Well,
If the
the-
doctor,
but I mean, a lot of cancers are curable, just depending on what stage you start the chemotherapy or radiation. I mean, as we spoke earlier, I know you're trying to do the best you can with this, but we are harming a lot of Tennesseans with this legislation. This committee has the opportunity to do the right thing and stand up and stick up for the majority of Tennesseans and put a rape and incest exception to this. Give doctors the ability to do what they're trained to do, because we are not medical professionals on this committee, and not have a draconian law in this state that's going to harm women. With that being said, I don't know how I can support this. Thank you, though, for your answers.
thank you.
Thank you. Chairman Clemens, you recognize.
Thank you, Mr. Chairman. I've only been up here 9 years, but I've never seen a bill pass through a subcommittee with only one negative vote and be so substantively changed at the committee level. And that really concerns me. And it really concerns me now, especially given the fact that a special interest organization that came before the subcommittee and offended the subcommittee and got reprimanded by the Speaker of this House in the subcommittee is now okay with the substantive legislation and amended here. That concerns me. And the reason is because of the substantive changes that are made to this bill in this amendment. Now, Representative, I sincerely appreciate your work on this. You care about this issue. You're passionate about this issue. And I understand you're in a difficult position. I think you're trying to do the right thing, and I appreciate that. On behalf of my family and women across the state of Tennessee, as well as healthcare providers, you're to be commended for that. What I'm concerned about is, a lot of the vagueness of this law has been questioned by members of both sides so far today, and some fair questions have been raised. My question is getting to the one posed by Representative Mitchell, in that at what point, where in that timeline, how close to death's door does a woman have to be before that doctor's decision is deemed reasonable?
I believe with Section 2, removing the affirmative defense, I believe it gives doctors the ability to take care of these pregnant mothers when their life is in danger. I was passionate about making sure that affirmative defense was removed from the legislation. And that was my number one goal. And when I have spoke with physicians, that has been their number one priority, is to remove the affirmative defense. And we're accomplishing that with this bill as amended. It will save mothers' lives. That's why I'm carrying it.
You recognize?
Thank you, and I appreciate that, and I recognize your intent here. We've changed the good faith judgment now, medical judgment, to reasonable, which is a step backwards in my opinion. But the language of this bill, I think we are still leaving doctors in jeopardy of criminal prosecution. They are still threatened with the criminal code that was referenced earlier in this committee, and they can still be charged. They're still going to have to defend themselves, and they're going to have to prove reasonableness. Now, in a court of law, if you got a eager enough district attorney, they're going to find another doctor that will testify against the doctor and say that was not reasonable. Now, that's why good faith is so important. I am afraid that in amending this and trying to appease too many people and extreme special interest groups, that we are not providing the level of protection to our healthcare providers that we need to be, and that we did in the subcommittee. We did. And that amendment is now gone, and I take great issue with that. Now, you might have a circumstance where a physician under this law, even with your intent, is posed with a situation where they are going to wait till the very last moment where a woman is bleeding out or stroking before they can substantively provide that evidence in court if they're charged with a criminal act. I would not ever want my doctor or my wife's doctor or any woman in this state in the position of having their healthcare provider sitting there waiting and concerned more about criminal prosecution than their life and their health. And that's what we're leaving here with this amendment. And that's the reason I'm concerned about how this amendment weakens the previous one and doesn't provide the level of protections for our health providers that we can, therefore risking the lives of mothers and their health. Now, we have the opportunity, if you know someone is going to have a difficult pregnancy. One of my colleagues testified as to her own story yesterday. They knew what would happen if she continued her pregnancy, and they were able to take action preemptively. That isn't allowed under this amendment. What is only allowed under this amendment is a reasonably medical judgment of substantial and irreversible impairment of a major bodily function or the life or an act to prevent the death. I mean, doctors are going to wait till the very last minute. And the question about whether or not they can treat cancer or give them chemotherapy, that's a toss-up. That's a toss-up. We're asking medical providers to make legal decisions instead of healthcare decisions. That is a dangerous game that we are playing with people's lives and healthcare providers in the state of Tennessee. So, and I know you're waiting for the question at the end of this statement. Are you, knowing how you feel about this, we've had conversations, knowing how passionate you are about this, are you comfortable with this language as compared to what we passed out of the subcommittee?
I am comfortable knowing that this language will pass and it will save mothers' lives by removing the affirmative defense. I have a daughter, I have 4 granddaughters, and I believe removing the affirmative defense will protect them.
You recognize?
Thank you, Mr. Chairman. I mean, we're only really amending subsection C with this amendment. Subsection B still makes a person who performs or attempts to perform an abortion liable for a Class C felony. And this makes that decision very hard for doctors, the way we're amending this, changing good faith to reasonable and leaving this to the very last minute. I have sincere concerns about that. I think I've sufficiently covered that. But we're also changing and stepping back from EMTALA standards. This is my final question, Mr. Chairman. EMTALA requires medical care when there's a condition that requires immediate medical attention, or otherwise there will be serious dysfunction of bodily organs. And this changes that language. How come we're stepping back from that federal standard?
According to the Section 2, this bill says to prevent the death of the pregnant woman or to prevent serious risk of substantial and irreversible impairment of a major bodily function.
You recognize?
Why didn't we just use EMTALA language there instead of that other language?
I can't answer that.
All right. Thank you, Mr. Chairman. Thank you, sponsor. I appreciate your work on this. I really wish we'd stuck with that original amendment. Thank you.
Thank you. Chairman Williams, you recognize?
Thank you. Thank you, Chairman. Thank you, Chair Lady. I just feel, first of all, I'd like to say, again, thank you for your hard work. I do think, as it relates to the physicians from my district that came, sat in my office for the last couple weeks, even though it's not the language some people on the committee might want, this is a language that the physicians in my community asked for us to change. And this is a result of your hard work and many people in the room's hard work as it relates to this particular thing. I think in the instance of the original bill, the last amendment, I think it doesn't, I don't think anyone's ever happy as it relates to language in this way. I think that the very fact that people are pretty dissatisfied means that we're probably in a pretty good spot, to be brutally honest. And I appreciate your hard work there. I do think for me and my district, I wasn't there until this amendment. It was not something that I really wanted to support. It was very difficult because many of my colleagues whom I have grown to love, and we stood here and for the last 13 years attempted to protect the unborn in the state. It felt like a reversal. But I do think that when I look at the language, like how it's clearly defined, when I look at what we've done in order to protect physicians, I think this is a good amendment. I think the supporting amendment that relates to reporting, I mean, many of us took a lot of heat years ago when we had opioid doctors and we had to do reports about how they were done. I think the reporting is an important component, which you added later. And I think it's a really good, I was not here 2 days ago. I simply wasn't, but I am happy to say that even though the House bill number is the same, this is a dramatically different amendment than we originally had. And so I wanted to tell you that. And I also wanted to say that for the purposes of the people from my district who reached out to me. Sometimes the House bill number gets a scarlet letter. And in this instance, it does in my community. But I want my community and the people that I represent to know that this is not, the letter may be the same, the numbers may be the same, but it's a dramatically different bill. And so I look forward to supporting it. Thank you.
Thank you.
Thank you. And I do have a question for you. And for the record, the surgical staff, including scrub techs, nurses, anesthesia, and other surgical staff in assisting a physician who has terminated pregnancy is not the same as performing or attempting to perform an abortion. So again, assisting is not the same as performing abortion. Thus, it is not the intent for the surgical staff or the nursing staff who are simply performing their duties in assisting in a procedure that they believe to be legal to be charged with a criminal abortion. Is that correct?
That's correct.
All right. Thank you. And let's see, Chairman Kumar, you recognize?
Thank you, Mr. Chairman. Thank you, Chairman Halton Haynes. I think the legislature in the state of Tennessee owe you a debt because you have tackled the most difficult issue certainly at this time in our legislature and certainly within the state itself. It's the most divisive issue. Certainly what is the procedure of abortion is a matter of freedom to some and murder to others. And there is no greater divide. It is so extreme in the sense that it is difficult to think that there is a mid road or a solution to it. And to tackle that, again, takes exceptional courage. It places a very undue burden upon the physicians. And as a physician, I've been concerned about that. They should not have to tackle with when do they intervene, how far do they intervene, and what do they do, and would that mean prosecution and basically financial and personal and professional ruin for them. And I think this amendment does address that. I think we have alleviated concerns about, again, molar pregnancy, ectopic pregnancy, as well as other conditions. I think that is accomplished, and that is very, very important to practicing physicians. Has everything been accomplished? No, it's not perfect, but nothing perfect is going to be achieved when the issue is as divisive as it is. That's just never going to be really possible. We are not going to be able to satisfy everybody. I think there are certain things that we do need to understand that when it comes to, are we going to let somebody bleed to the last minute? I think those are exaggerations. I think it's also exaggeration to say that the battle between cancer chemotherapy and termination pregnancy. I mean, cancer is a threat to life. It should be there. It may not be immediate, but it's an impending threat. And that is why we fear the word cancer and the way that we deal it. The fact also remains that Tennesseans are conservative by values, and we as their elected representatives bring those values here. The solutions are going to be conservative, but they are also going to be humane and of concern for our citizens as well as practicing physicians. And I think you have really, really done the best we can. Congratulations. And well, more, there is no congratulations out of this, but more, I would say, thank you. And again, the legislature and the state of Tennessee owes you a debt. Thanks a lot.
Thank you.
Thank you. And before we vote on this, I would like to say a few words. And I think it's important for people to know that fixing ectopic pregnancy, that issue, fixing the life and health of the mother issue, and the affirmative defense issues that were important to you were important to me as well. And as chairman, I actually, before session even started, I spoke with pro-life leaders to express my concerns on those issues. And I even filed my own caption bill because I felt so passionate that we needed to address those issues. And so I'd like to thank Chairlady Haynes for her hard work that she's put in this legislation and for stepping up to address this issue that we're facing. This is a difficult issue with a lot of medical, legal, and even societal technicalities, and getting a piece of legislation that threads that needle has been a Herculean effort. And Chairlady Haynes, you should be commended. I appreciate the efforts put forth by our speaker, our legal team, and other participants, including members of this committee and subcommittee. I believe the bill as drafted will place Tennessee on firmer legal grounds to protect the unborn, while also taking into account protections for the life and health of the mothers and the doctors that take care of them. Because of my concerns, I voted no on this bill in subcommittee, but with the amendments that have just been attached, I will be supporting this legislation today. So without objection, we are voting on the bill.
Thank you.
All those in favor of House Bill 883 as amended, say aye. Aye. Opposed? Ayes have it. Bill goes on to Calendar and Rules.
Thank you, Mr. Chairman and committee.
Without objection, we are adjourned.